We're glad to have you today, and I hope you enjoy it. And everyone watching, I hope you enjoy David's presentation as well. So I'm just going to give you a quick introduction, and then feel free to get started.
Sounds good.
So David is a business lawyer and facilitator and the managing principal at DSBL Business Law. He has extensive background in advising business owners on the sale and purchase of their businesses, and in helping business owners maximize value by positioning the business for a sale. David has also been working with business owners and family enterprises for more than 35 years, helping them structure business and shareholder arrangements and guiding them through the succession and estate planning process. So thanks again for speaking today, David, and good luck with your presentation.
Thanks so much, Alex. Thank you, and good afternoon, everyone. The title of my presentation is Running Your Business as If It's for Sale. And we're going to talk about communication, which is critical when you're thinking about selling your business. As my friend Tom Dean says, silence is the great destroyer of wealth in a family business, and I've seen that far too often. We're going to talk about contingency planning, or dealing with the what-ifs, and we'll talk about dealing with the skeletons. The upshot of which is, just because you don't think that a particular issue is important to your business doesn't mean that your buyer will agree with you. And we're going to get you to start to think like a buyer, because buyers don't like surprises. So who are the stakeholders when you're deciding whether to sell your business? Some of them are going to be more obvious, like if you're dealing with a family-owned business, members of the family, both those that are involved in the business, those that are not, employees of the business, because their livelihood will depend on where the business is going. If it's going to be sold to a third party, of course, you've got customers, suppliers, etc. But one that may not easily come to mind is, for instance, the community. So if your business is the major employer in a smaller community, what impact will the sale of your business have on employment in the community and in general in terms of the local economy? So certainly a factor to be taken into consideration. Next, we want to know who you may need to have on your team to proceed with your plans, because it is a multidisciplinary approach, and you're going to need the advice of a number of different people. So your accountant and your lawyer, those are probably easy enough to contemplate. But what about a valuator? Why shouldn't you really know what your business is worth before you decide to sell? Just because your golfing buddy told you that he's sold his business and it's a similar one to yours a number of years ago, and he got X for it, so many times multiple, etc., doesn't necessarily mean that that's going to apply to you. Another expert that you might want to consult is an HR expert, because to the extent that a buyer is going to come in and potentially terminate a number of your employees, quite apart from the emotional, social, human cost of that, what about the financial cost of that? Who's going to pay? If there are severance payments to be paid, and they can be quite hefty depending on the size of your employee complement, who's going to be looking after that? At least you're prepared for that part of the negotiation with a potential buyer. Wealth manager, financial planner, it goes to the question of how much money do you think you're going to have at the end of the day after you've paid your taxes after the sale? Is that going to be sufficient to fund your retirement if you're at that point in your life? Those are the kinds of questions that you'd be asking there. And an M&A advisor on the issue of how should you prepare your business for a sale? And a mergers and acquisitions advisor is got the job of going through your business with you, determining the pluses and minuses, and getting you prepared for a sale. And we'll talk about that a little bit more as we move along. So starting with family, again, family-owned business. Let's say your daughter, who works in the business and thought that someday she was going to own it. Now you decided to sell it to an outside buyer because you want the cash, you want your nest egg to be secure. Question is, have you shared that information with her? What's in it? If not, and if you do share it with her, what's in it for her to stay? In some instances, depending on her role in the company, the purchaser may want to keep her on after the sale. What's the incentive for her to continue. And a similar question for other key employees. A buyer could consider them very well to be part of the goodwill of the business. Why they're paying you a premium? Because their expectation was that your key employees were going to stay on for 1 year, 2 years, 3 years after the closing. But if you haven't taken your key employee into your confidence and they hear a rumor on the street about a potential sale, they could be gone. And whatever goodwill was attributed to their role would be gone with it. So your accountant. Some people just assume that they're entitled to the lifetime capital gains exemption on a sale of shares, but there are rules attached to that entitlement. And if you're looking to maximize on the exemption and perhaps create a family trust and include other members of your family and maximize on the capital gains exemption, that's a conversation you need to have with your accountant. And to do so early, I'm talking about years before you go to sell, because you want to take advantage of the potential uptick in value of your business as time goes on. In addition, particularly in the times of COVID, you may want to have a discussion with your accountant as to whether or not now might be a good time for you to do an estate freeze, because the values, for instance, of your business might be on the low end at this point, and as we're climbing out of COVID, there could be a rise in that value. The issue of corporate lawyer and estate planning lawyer, I found that clients tend to deal with their professionals on a need-to-know basis. So your lawyer knows things that your accountant doesn't know, and vice versa. And sometimes you employ different lawyers for different purposes, a corporate lawyer and an estate planning lawyer. So for instance, there's your corporate lawyer who's helping you out with a reorganization, perhaps in advance of a sale. Does he know, has he asked you whether you've got a will and a power of attorney in place? And we'll talk more about that in a bit. The estate planning side, succession planning side, they're interrelated, and you may not be dealing with the same person, same advisor for each of those. And so it's critical that your advisors be singing from the same song sheet, so to speak. And again, we'll have more to say along those lines as we move along. So your financial planner and your wealth advisor, I already referred to that in a previous slide. Someone has to sit down and do the math. So for instance, if you're going to be selling, if you do decide to sell and it's a family-owned business and you're going to sell to the next generation, you want to have someone do an analysis and determine whether you can afford to get paid out over a period of time and whether the business can afford that extra layer of cost as you're getting paid out. One of the problems with selling to family is business owners tend to be a little bit generous with next-gen payouts, maybe 5 years, 7 years. And if you were counting on the sale of the business as your retirement nest egg, the question is, how secure are you? And if you're at all nervous about how the business is going to be managed when you're not there, then the issue becomes, did you really retire at the end of the day if you're constantly looking over your shoulder? And it's worse because you're not running the business on a day-to-day basis, but you're nervous about how it's being run and whether ultimately you're going to get paid out what's owed to you on the buyout. So another interesting thing that happens, particularly when you sell to children on a long-term payout, is suddenly you're not the only boss, right? Previously, you were the boss. All of your children were employees. Now, if they're buying you out over a period of time, what's that going to look like? And what's your relationship with them going to look like if you're a boss, a partner? And so you really do need to sit down, and that's an extensive discussion. What are the rules going to look like? And are you going to embody those rules in a partnership agreement or a shareholders agreement, which you should? Your M&A advisor, again, as I previously mentioned, selling your business is not like selling a house. You don't put up a for sale sign. It's a process. And it takes time, and you've got to give yourself enough time. Got to find out what the business is worth. You got to find out what a buyer is looking for, where you've got some issues, where you've got some gaps in management, perhaps, and fill fill those in. Just a comment about enterprise goodwill and personal goodwill. If you got hit by a bus tomorrow, would your business survive? I mean, that's the difference between enterprise goodwill and personal goodwill. Buyers are looking for enterprise goodwill. They want the business to be able to survive, whether you survive, you personally survive, or not. And if the answer is that the business dies without you there, how valuable do you think that your business is going to be to a potential buyer? So lots of advisors with different kinds of expertise. And the question is, as mentioned before, is everyone singing from the same song sheet? Is everyone aligned? The recognition has to be here that it's a collaborative process, that you need the advice of a number of different advisors. And so the blueprint has to be the same for all of them. Now, in addition to deciding who's on the team, and I gave you examples of the kinds of folks, kinds of advisors that you might want to turn to, more often than not, it's useful to have one of your advisors, whether it's your lawyer, your accountant, your wealth advisor, or someone else, acting as a quarterback, which is often the role that I tend to play when working with family business owners. So in terms of the role of the quarterback, in a family business, it starts with the family. Each family business is a little bit different. Each family member has to be given an opportunity to be heard and respected. And for me, in order to help the family map out a transition strategy, a sales strategy, I need to know what's really going on in the business and among the stakeholders. And to do that, I meet confidentially with each of the family members in order to establish trust and to find out what their particular concerns are. So I sort of see myself as, in terms of my role, as a kind of a cross between a minesweeper and a shepherd. The minesweeper is trying to discover what are the obstacles, what are the impediments to getting this plan done. If there are problems, can these mines or issues be diffused, or do we have to find a way to navigate around them? And then the shepherd's role is keeping everybody focused on the big picture. It's kind of, and in terms of a goal, an orientation, it's like the Rolling Stones lyric that you can't always get what you want, but we have to work hard to try to get each stakeholder what they really need. Second role of the quarterback is making sure that all of the advisors, as I said, are singing from the same song sheet, that they're focused on the big picture, and to maintain the momentum necessary to get the transaction done. Let's move on to contingency planning, or dealing with the what ifs. So the question is, what if you die or you become disabled at some point in time, either before you enter into a letter of intent or a purchase and sale agreement, or on your way to a closing, so to speak? What now? Well, I mean, a simple question to ask yourself, or for your advisors to find out from you, is, do you have a will and a power of attorney in place? I mean, you'd be surprised how many people answer that no. So let's say that you do have a will. Most wills tend to say, when I die, everything goes to my spouse. If my spouse dies before me, then it all goes to my kids to be divided equally among them. So the question is this: if your kids are not involved in the business, or some are, some are not, what do they know about the business? What have you done to educate them? Because what you've created is an accidental partnership among them. Right? And are they ready to be in partnership with each other? How, for instance, do the children that are involved in your business feel about being in partnership with their siblings who are not involved in the business? So one of the things that I do early on in an engagement with a family is I do what I call a fire drill. And so for a fire drill, I tell the parents to take a hike, and I just meet with the children of the family, both those involved in the business and those that aren't. And I tell them the sad tale that their parents just went down in a plane crash, and it's a Friday afternoon. And in addition to grieving, we've got to send a message out to the suppliers, the customers, the employees of the business, our banker perhaps. What's the message that we need to send out, and what should be our next steps? And then I put my pen down and I sit in silence waiting for a response. And sometimes the silence in the room can be particularly deafening because no one has really thought this through. No one has prepared for it. And what I've created, in a sense, is a sort of a virtual death event. This is what life is going to look like for all of you if the founder of the business, the boss, so to speak, is gone. Right? Is this something that you really want to live through? Or should you be getting the background, the education of knowing what's going on so you have the ability to understand and carry on? What I would call emergency succession planning. So, okay, maybe you do have a will. How old is your will? You know, maybe it was prepared 25 years ago. Are things the same today? Likely not. The other thing you should know is that in Ontario, a practice has grown up over many years that if you own a business, you can create two wills and put the shares of your company in a second will, which doesn't get probated, and thereby you can avoid Ontario probate fees of approximately 1.5% on the value of your business, which is often your most valuable asset, and potentially you could save your estate a fair bit of money. So some more examples of some what ifs. Your partner has early dementia and she left her shares under her will to her husband. Are you prepared to have her husband as your partner? Which you will have if you don't have a shareholders agreement that specifies what happens on the death of your spouse and gives you rights of purchase in that sort of an event. Also, if your employee quits, for instance, another what if, what does your management team look like with that employee gone, and how does that impact you on a potential sale? So one of the best ways I know of to deal with the what ifs is a shareholders agreement. The shareholders agreement can be a way to educate the stakeholders of the business and to professionalize it. So what do I mean by that? Well, I find that a common mistake that family business owners and their advisors fall into is they treat a family-owned business as some unusual creature that doesn't have to abide by normal best practices or business practice rules. Anything goes. You don't have to compare yourself to a business that is not a family business. And I try to get them to answer the question, are you a family-owned business, or are you a business that happens to be owned by a family? And where that takes you is that you should be able to answer that no, we should be running our business as if we are a non-family business, meaning that we should be introducing the same kinds of disciplines and best practices that go on elsewhere. Because from a buyer's perspective, they don't care whether you're a family business or not. They want to know that your financial statements are a true reflection of what it costs to run your business. And if you're paying your sons or your daughters the same money, by way of example, even though one is the CEO and the other one works in the shipping department, that's not going to inspire confidence on the part of your buyer. The shareholders agreement is also going to deal with some of the core what ifs, such as what I call the 3Ds: death, disability, and divorce. And it'll provide for potential buyout rights by the remaining shareholders if one of those types of events happens, and including the payout terms, and if there's insurance or providing for the possibility of putting insurance in place. The shareholders agreement can also provide for how you deal with a business divorce or a fundamental disagreement, and in particular, for instance, a fundamental disagreement as to what happens when an offer comes in to buy the business. What if that happens and your partner doesn't want to sell? Well, if you have a shareholders agreement and it provides for a first right of refusal and a drag-along provision, that will provide that if your partner, if you present the offer to your partner from the third party and he doesn't agree to buy you out at the same price within a certain period of time, usually say 30 days, then you can sell. Not only can you sell to that third party, but you can also force your partner to sell to that third party on the same terms. Now, I have a problem with rights of first refusal because of that. The question is, when were you going to introduce to the buyer that, oh, by the way, after we've negotiated all of this, my partner has a first right of refusal to buy. And so I have to give him the opportunity to buy on the same terms. That's a kind of an unnerving situation if you're introducing it late. And if you introduce it early, what position is the buyer going to take on that? So when I refer to a ROFO, it's what I call a right of first opportunity, which is a little bit different. So you go into your partner and you say, I'm interested in selling my share of the business. Are you prepared to buy? And here's the price that I want. And if your partner has X number of days, and if your partner says no, and you also have a drag along provision, then that allows you to go out and potentially find a buyer, as long as you're finding someone who's prepared to buy at or above that price. Then you don't have to come back to your partner anymore. You can sell to that third party, and because of the drag along, you can drag your partner along on that deal. A few lessons from COVID. Thing to know about COVID is the lawyers don't really have it wrong. Bad things can and do happen, perhaps not as severe as COVID. But the other lesson is that the fundamentals of how you run your business haven't changed that much as a result of COVID, but at least COVID should have started you thinking and preparing for the what ifs. So let's move on to dealing with skeletons. This is really an important takeaway. Too many business owners fall in love with their business. Don't fall in love with your business. Just because you think a problem isn't a problem doesn't mean that your buyer is going to agree with you. Sorry, I just want to make sure we're on the right page. And believe me, whatever your business is, I'm sure that you've got some skeletons for sure. So you need to take off your buyer's hat. Sorry, you need to take off your owner's hat and take off your rose-colored glasses and start to think like a buyer. One of the first things that a buyer is going to want to do after they sign a non-disclosure agreement and maybe a letter of intent is to do an extensive due diligence search. And what they're looking for is how you operate. How true are your financial statements? And are there any skeletons? The buyer is concerned about those to the extent that those skeletons are going to put the buyer at risk following the closing. That investigation will ultimately translate into 8 to 10 pages or more of representations and warranties in the purchase agreement, meaning that you're providing guarantees on things like the following. Here's examples of, these are sort of watered down, some of the representations and warranties that you could face in a purchase and sale agreement. There are no legal proceedings in progress, pending, or threatened. So what about that 20-year employee that you let go when the COVID hit? Maybe she sent you a threatening letter, which you threw in a drawer. Well, you need to know that you're going to have to disclose that. And if you're prepared for it, you're prepared for that sort of a question, or better yet, you've dealt with that before you've selling to a buyer, then you have the opportunity to frame your response in your own way. Another one, the business is in compliance with all environmental laws. So if your buyer is financing the purchase of your business using his bank, well, rest assured that if it's a bricks and mortar business, they're going to want to conduct an environmental investigation, which is known as a phase 1 audit. So the question is, have you been diligent observing environmental standards? And if you've been, if you're using hazardous substances in your business and you've just been spilling them in the back somewhere, not complying with environmental standards, and that seeps into the ground, and they do some drilling on a phase 1 audit and determine that there's contamination in the ground, who's going to pay for that? And why should you be so this is why I talk about running your business as if it's for sale. Why should you be confronted with that as an issue at the time run your business in compliance so you don't have to face that issue when it comes time to sell the business. Since the date of the financials, there's been no material adverse change. So what if a major customer or supplier, someone that accounts for, let's say, 30% or more of your business, has told you that they're leaving, or some other obvious economic adverse change? You've got no choice but to disclose that to the buyer and explain how you think that will impact your company's earnings. And if you've given yourself enough time, you can put the proper spin on that or find a way to deal with it in advance of a closing. That the business owns its trademarks and copyright and there are no third-party infringements. An interesting exercise for you might be if you want to Google yourself and see, particularly if you're engaged in internet sales and online selling, you may find that there's someone out there that's using your name. So what are you doing about it? Or that you're using someone else's name. And if you're not protecting your intellectual property rights, that's going to have an impact on the buyer and particularly, and also potentially on the sale price of your business. So the issue of getting an assignment of copyright arises when you've got, let's say you enter into a software development agreement and you pay a software developer $100,000 to create a software program for you, and it becomes a really valuable program, and then the buyer on a sale is asking you, show me an assignment of the copyright rights to that program. And you look at your contract and there's nothing in there. So now you're running to chase the developer of the software, assuming that he's still around. You also discover that he's pissed off at you because you didn't pay him out the full value of his contract. So what's that going to look like as you approach a closing? Some of the other potential hurdles to a closing that you need to deal with early are third-party consents. So, such as a consent to an assignment or a change of control, your landlord, your franchisor. And the thing to recognize there is it's not a slam dunk necessarily, depending on your agreement. There could be some discretion on the part of your landlord or franchisor, let's say in particular. They want to vet the buyer. They want to find out whether this person's got the proper financial credentials, et cetera, et cetera. And if you leave it too late, you're scrambling and you may have to give all kinds of concessions in order to get that consent that you wouldn't otherwise have had to give if you planned for it earlier. Also be aware that a sale of shares of your company represents a change of control, which also triggers a deemed year end. So if you can, and that means another set of financials, another set of tax returns. So if you can close your transaction, if you can schedule it at your year end or close to your year end, you can avoid having to prepare another set of financials. So just a word about vendor due diligence. If you're agreeing to take a vendor take back, which is a form of security for the balance of the purchase price, then do some due diligence on the purchaser, because if the purchaser is a shell company that the buyer set up in order to buy your business, and the collateral that's standing as security for your VTB are the assets of your business that you sold to that buyer, and then the business gets run into the ground, the question that you need to ask is, what have you got at that point? What is your security worth? So the bottom line here on the due diligence and dealing with skeletons is this. It's really not magic. You have the ability to conduct your own due diligence. You don't have to wait for the purchaser to prepare their due diligence checklist. A lawyer who practices in the mergers and acquisition space can take you through an extensive due diligence checklist, as can your mergers and acquisitions expert. And that, in turn, gets you prepared to, first of all, recognize where the risks are, and then try and focus on ways to deal with them. So all of which goes back to the point that we started with, which is don't fall in love with your business and start to think like a buyer. So where are we? So what are the takeaways for today? Develop a transition plan. You have to recognize that it is a process and it takes time. You need to communicate with your stakeholders and with your advisors. A shareholders agreement, if you have more than one owner of the business, is critical because it manages people's expectations, gives you an opportunity to set up rules from a business practices standpoint. And rules that also deal with fairness and appropriateness, and it gives you an opportunity to deal with the what ifs and plan ways of coping with them, such as a death, a disability, or an offer that comes in that only one of the partners is prepared to accept. You have to understand that powers of attorney and wills and a succession plan are two sides to the same coin, and you need to focus on both. Tax planning takes time, and you may lose out on the ability to maximize your capital gains exemption with a family trust if you're looking to close within 6 months after you've gone through that kind of a plan, and it doesn't make any sense to do that unless you've given yourself some time for the business to grow. Thinking like a buyer, skeletons don't disappear on their own, and hopefully one of the things that you've recognized as a result of this session is that there's a lot that goes into it, a lot of different pieces of expertise. You can't do it on your own, your trusted business advisors are worth the effort and the expense. So that brings me to the end of my presentation. My contact information is in your material. If you have any questions, by all means, you can present them now. But if you want to reach out to me after the conference, I'd be happy to hear from you. You can call or email me. So thank you very much for listening, and enjoy the rest of the conference. I guess I'm waiting for someone to...
Hi.
There we go. There we go. Okay.
Yeah, unfortunately, there is no questions here. There is a note here saying thanks for your presentation from Mark. But yeah, I just want to say thanks again. And yeah, everyone has your contact information, so we'll be able to pass that to them post-event as well. But thanks again. It was really great.
Great. Thank you so much, Alex. Thanks for your help.
Bye.
Bye-bye.